The Students First Act of 2011 is designed to improve the quality of public education in the state of Alabama by providing fundamental fairness and due process to employees covered by this act. It also restores primary authority and responsibility for maintaining a competent educational workforce to employees covered by this act, and enhances the ability of public educational agencies to increase student academic achievement and student performance. It also invests employers covered by this act with the discretion and flexibility necessary to make the most effective use of limited educational resources and eliminate costly, cumbersome, and counterproductive legal challenges to routine personnel decisions by simplifying administrative education and review of contested personnel decisions. So who is covered and not covered under the Students First Act? The individuals who are covered under the Students First Act are tenured teachers. Tenured teachers are teachers who have completed 3 years of teaching in the same school system. It also covers principals who are tenured, full-time bus drivers, full-time cafeteria workers, full-time custodians, full-time instructional aides, unsupervised survivors, and secretaries or clerical assistants. The Students First Act defines full-time as any person who works 20 or more hours in a normal work week. Those who are not covered under the Students First Act are the chief school financial officers, superintendents, and temporary or part-time employees, which would include summer school teachers, substitutes, seasonal or supplemental employees, etc. What is protected under the Students First Act? Tenured teachers, which is a teacher who has completed 3 consecutive full years. October 1st is when a year is considered complete. So, if an employee earns tenure and then leaves, they lose their tenure and they are therefore no longer protected under the Students First Act. This Act provides certain due process rights in the event of transfer, suspension, or termination are proposed. However, the employee does not gain protection in a specific position. Non-renewals and terminations. Non-tenured teachers. If a probationary or non-tenured teacher, they must receive notification from the superintendent 30 days before the board meeting if they are being terminated. If it is a first or second year employee, they must be notified of termination on or before June 15th. If it is a third year employee, they must be notified on the last working day of the school year. For a tenured teacher to be terminated, a tenured teacher must have a justifiable decrease in the number of positions, incompetency, insubordination, neglect of duty, immorality, failure to perform duties in a satisfactory manner, or any other good and just cause. For a tenured teacher to be terminated, the superintendent must issue a notice of the board's decision. The teacher may then submit a written statement prior to the board meeting. The board members then may vote regardless of submission of a written statement. So whether the teacher submits a statement or not, the board will vote. A majority of the board must approve the superintendent's recommendation for termination of the tenured teacher. After they vote, the superintendent must issue notice of the board's decision, a written notice of the board's decision. The decision is then final and effective immediately, and the teacher has no further right to challenge or appeal the board's decision. These are the steps for terminating tenured employees. The superintendent must issue a written notice. They must also include the grounds for termination as well as facts underlying those grounds. Statement that employee has 15 days to request a hearing, and the employee receives pay for 75 days after termination if it is determined that they are terminated. If a teacher is convicted of an act of moral turpitude, they will receive immediate cutoff of pay. Moral turpitude has not been defined, but some things that it could include is immorality, abandonment of job, or incarceration, and therefore neglect of duty. Reassignments and transfer. A reassignment is defined as a change in grade, position, or work location within the same school, campus, or facility. A transfer is a change in a teacher's position or work location outside the currently assigned location. So there are 3 different scenarios that could happen. The first one is a reassignment within the same school and the same pay. This means that a teacher has a change in position or grade. The superintendent has to make that decision and notice within the first 20 days of the school year. This can only happen once a year. The teacher must be qualified for the new position, and this is not subject to review and not subject to board approval. It is up to the superintendent to determine. The next scenario is a transfer to a different school with the same pay. This is a change in position or grade. The teacher must receive notification from the superintendent, and this includes a conference with the superintendent. This must also occur within the first 20 days of the school year, and it can only occur once a year. The teacher must be qualified for the new position, and it is not subject to review. And then finally, there is a transfer within a different school, same pay and different feeder pattern. And this is a change in grade or position. Teacher must be notified from the superintendent. This does require a board meeting. The superintendent therefore must recommend that the teacher be transferred, and the board must vote and the majority approve his or her recommendation. This must occur in the first 20 days of the school year, and it can also only happen once a year, and it's not subject to review. Okay, terminations due to certificate actions. A certificate could be revoked for criminal conviction, and in this scenario, the superintendent must recommend in writing the termination of the teacher. The board must vote with majority approval. If approved, the superintendent must notify the teacher, and the decision is final and effective immediately. If the criminal action is overturned, the board must then reinstate the teacher after the state superintendent certifies the teacher. If there is a significant action taken on the teacher's certificate, that means the certificate can be revoked, denied, suspended, or forfeited, or the employee could be declared ineligible. If any of those things happen to the teacher, the superintendent must recommend to the board to terminate the employee. The board will then vote, and if the majority approves to terminate the employee, then the superintendent must issue written notice of the board's decision. The decision is final and effective immediately. Suspensions. If a teacher is suspended and it is proposed that they are suspended for 20 days or less, the superintendent issues the notice with the reasons for the suspension, and the teacher may request to address the board. Whether the teacher makes that request or not, the board votes, and if majority approves, the superintendent must provide notice of the decision. The decision is final and effective immediately. If the suspension is for more than 20 days, the superintendent still issues the notice with the reasons for suspension. Teacher may request then to address the board. If that is the case, the board needs to ensure a court reporter is hired, and they need to file a report of contested personnel action to the State Department of Education. The board returns to open session to vote, and the superintendent will then issue the written notice of the board's decision. Partial cancellations and reduction in force. Partial cancellations applies to all employees. Reduction in pay is based on the length of the workday or school year. It is not considered a termination or partial termination as long as action is prospective in effect in the future, or the superintendent recommends and the board approves, or it is applied to similarly situated employees within the system department categories or divisions. A reduction in force. These actions are specifically excluded from the Students First Act. This applies to employees to be laid off due to the reduction in force. However, it must comply to the board's reduction in force policy. If the board does not have a reduction in force policy, then the employee could file an action in the state court.